for joining us. My name is Kelly Weiner, and I'm the managing attorney at Scott Legal. We're going to spend some time today talking about the National Interest Waiver Green Card, also known as the NIW. This is an underutilized category and one we've seen be used more and more for people to get a green card, particularly entrepreneurs. So a few things before we get started. Scott Legal is a full-service immigration firm, but we offer a number of different types of visas, including in the NIW category. We also offer several webinars a month, and we will continue doing our webinar series indefinitely. At the end of this webinar, we'll send out a few things. So one is a PowerPoint on the National Interest Waiver. Another is a link to where you can sign up for additional webinars. And finally, a copy of this PowerPoint will also be available. So for the panel today, I am Kelly LeGrand Weiner, the managing attorney of Scott Legal, and I will be here to discuss the National Interest Waiver. I have many years of experience processing this, as do many members of our team. Finally, this webinar is being recorded and will be made available on demand. And if you have questions throughout the presentation, please send them through the chat box, and we will get to them either during the presentation if it's relevant, or at the end of the presentation, we'll have time for questions. So we will now get started to talk about what are the National Interest Waiver requirements. So the National Interest Waiver is a green card category. This means that if you are successful in getting a National Interest Waiver, you will have a green card that allows you to live and work permanently in the United States. The National Interest Waiver is under the EB-2 green card category. This means that there is a threshold requirement of either an advanced degree, so master's or higher, or its equivalent, which would be a U.S. bachelor's degree plus 5 years of post-baccalaureate progressive work experience that's relevant for the field. Or if you don't have a degree, you can also try to qualify for the EB-2 using exceptional ability. So exceptional ability is a degree of expertise significantly above that ordinarily encountered. So, this is in contrast to extraordinary ability, which is another term you'll often hear for the EB-1 or the O-1 categories. For extraordinary ability, this is a level of expertise indicating someone is one of a small percentage who's risen to the very top of their field. So exceptional ability is a lower standard than this. This is why sometimes the NIW can be a good category for people who may be thinking about the EB-1A extraordinary ability green card, but maybe are not quite there yet in their career. But perhaps the EB-2 NIW may be a good category for them. So if you're going to qualify based on exceptional ability, there is a two-part test. So first is you need to show that you meet at least 3 of 7 criteria, and they're listed here. I'm not going to name them all, but they're listed here. So you need to show, at least 3, ideally more if you can. So first they're going to look at, do you meet the plain language of the criteria? So for example, are you a member? Do you have a membership in a professional association? And if you do and you submit evidence of that, you've met the first part of the test. But then there's a second part, which is, does that membership show that you are someone who has a degree of expertise above that ordinarily encountered, right? So if you are just a member of an association that allows you to join because, for example, it's a law association, you have a law degree, you pay a yearly fee, you can join. This is not a good piece of evidence for exceptional ability because anybody who has a law degree can join. So you would really need to show that you were invited to be a member of a professional association that requires some type of extraordinary or exceptional achievement of their members. Perhaps you need to have, accomplished certain things within your industry, won significant cases, been invited to speak, as a keynote speaker, been recognized as a subject matter expert in your field, through various mechanisms. These are the types of things that you're going to want to show for the exceptional ability, category. So, and again, this advanced degree or exceptional ability, these are just the threshold requirements. So you have to have either one of these to qualify for an EB-2. If you qualify based on that, then you're able to, apply for the National Interest Waiver, and then you need to meet all of the National Interest Waiver requirements. So for the National Interest Waiver, basically this is saying that, it's in the national interest to waive the normal requirement of a job offer and labor certification. So in a normal EB-2 process, the government requires that a U.S. employer goes through a labor market test to prove there are no willing, qualified, and available U.S. workers to hold this particular position. So for the national interest waiver, we're basically saying, because this there's an endeavor that has substantial merit and national importance, this person is well positioned to advance the endeavor, and on balance, it would be beneficial to the U.S. to waive the requirements of the job offer and the labor certification. So you need to meet each of those criteria to qualify for the national interest waiver. You have to have a proposed endeavor, and that proposed endeavor has to have substantial merit and national importance to the United States. You yourself need to have a track record showing that you have the ability to advance the endeavor. It doesn't mean that you have to already be doing this particular endeavor successfully. But for example, if you are building up a certain type of company, the fact that perhaps you had built up a certain type of company in the past and then sold it for a large profit or made it very successful, that would be very compelling evidence to show that you're well positioned to advance the endeavor. You don't have to have something that compelling, but you do need to be able to demonstrate through, your history, that you would have the ability to advance this type of endeavor. And they will look at things like, your past work experience, your education, your degrees, and any proof you can have. We'll talk a little bit more about other types of evidence you can submit to meet all of these prongs. And then finally, the third prong, if you meet the first two, often it can be, relatively easy to meet the third prong. If you show that you yourself are so talented in this field that even if there are other U.S. workers doing this work, it's still beneficial to the U.S. to have you doing this work. That can be a compelling argument. And then we'll talk a little bit more in the next in the presentation about how entrepreneurs can also be eligible for this. All right, so in particular, the national interest waiver has become much more friendly for entrepreneurs in recent years. There was a change to the standard of how NIWs were adjudicated in a case called Matter of Danazar. And in this case, there was specific language that was extremely favorable for entrepreneurs that indicated that the government views this as a category that should be used by entrepreneurs. So we've highlighted here some of the most beneficial language. So one particular change that was very beneficial to entrepreneurs is that when you're looking at substantial merit and national importance, the benefit to the U.S. interest can be local. So if you are hiring in an area, that's economically depressed, that has, had issues, with employment, that can be something that is utilized as a factor to, show, national interest and substantial merit. So previously, there was more of a focus on the endeavor being kind of covering a large geographic area. This was a really great change that showed that if there is an impact even in an area that is more local, that's okay, because solving unemployment in economically depressed areas does have national importance. Another thing that was, mentioned in Danazar that's very helpful is that entrepreneurs themselves are self-employed, and often they are not even eligible to go through the normal labor certification process. One of the requirements as part of the PERM labor certification process is you need to show it's a bona fide opportunity that was actually open to U.S. workers. So if somebody owns a company outright, they're really not going to be able to meet that standard, because the government is just not going to believe that they're going to hire somebody else in lieu of themselves when they own that company. So it is essentially impractical or impossible for them to obtain a green card through that mechanism. So that can be used on the third prong to show, on balance, it's beneficial to waive this requirement because it would be impossible to meet this requirement for entrepreneurs. Another favorable thing in Danazar is that there was a specific language that noted that entrepreneurial work can lead to an NIW, and also that the planned venture does not need to ultimately succeed. So you need to show that the venture is more likely than not to succeed, but it doesn't need to show, there's not kind of a really, really high standard of it already has to be successful. So this is helpful in showing that NIWs can be granted for startups. They can be granted for entrepreneurs who are trying out new ideas. And it's not necessary to, prove beyond a shadow of a doubt that the business will be successful or to have a business that's already successful. It can be a startup. Let's talk a little bit about timing. So when, many people who are interested in the EB-2 NIW are already in the United States on some other type of non-immigrant visa. It is important to kind of plan, look at your underlying status, think about your goals. Do you plan to stay in the United States? Is it more important for you to be able to travel, or do you primarily live outside the United States? These are all important things to discuss with your attorney in terms of your goals when thinking about moving to a green card in the United States. So, in terms of timing, there was, favorable changes, in the past, few years where premium processing is now available for NIWs. You can get an answer within 45 days if you pay the premium processing fee. If you go through regular processing, then the I-140 can be pending for quite a long time, even up to and over a year. If you're on a non-immigrant visa that doesn't allow for dual intent. So dual intent means that you are permitted to be here temporarily while also planning to adjust status, to get a green card in the United States. Some visa categories like the TN, for example, you need to demonstrate you have a residence in your country, or a home country that you don't intend to abandon. So that's contradictory, right? How can you be have a residence in your home country you don't intend to abandon, and you're also in the process of applying for a green card? So that's where it can make it a bit more difficult with these categories, when you are, going for the green card. It doesn't mean it's impossible. You certainly can, and we have many clients who have moved from a TN or an E1, E2, E3, to ultimately to a green card. But it does mean that you need to, think more strategically about, when you're applying, when you're filing the I-140 petition, when you're filing your green card application. These are all things that you would need to keep in mind because, for example, if you were applying for a TN and it came up that you had an I-140 pending, that could lead down a line of questioning that might lead the officer to believe that you have immigrant intent and are not eligible for that TN. So all important things to keep in mind and to discuss with your attorney, to make sure that you're planning to ensure you have work authorization in the US, if that's what you want, while you wait for the EB-2 NIW to go through. So in terms of the actual application process, you submit Form I-140 with proof that you meet the EB-2 qualifications. So that's what we just talked about, either the advanced degree or the exceptional ability, and then proof that you meet each of the 3 criteria for the National Interest Waiver. If there's an immigrant visa available, you may be able to concurrently file the I-485. So let's say you're in the United States in a valid status like E2, and then you go ahead and you file your I-140. If the EB-2 category is current, you can also file for your green card using Form I-485. You can also simultaneously apply for work and travel authorization. Something to keep in mind is you can't travel, once you filed your I-485 until you get that travel authorization approved. So, is the category current? That's the big thing this year for EB-2s. Unfortunately, EB-2s were retrogressed earlier this year and have stayed retrogressed, worldwide. So it's very common that this category is retrogressed for people born in India or born in China, but now it's retrogressed worldwide. We are hoping to see movement on it in the later part of the year as the fiscal year changes. However, it is very possible that this category, may, go back and forth on being retrogressed. So it's definitely something to keep in mind that if you want to be working in the United States and the category is retrogressed, then filing an I-140 doesn't give you any status in the US. You need to have an underlying visa status if you want to be here. So let's look at the pros and cons of adjusting status versus consular processing. So as I mentioned, unfortunately, right now, like let's say you're filing an EB-2 NIW today, you're not going to be able to also file for an adjustment of status because the category is retrogressed. However, in the event, that the category, changes back to current, in the coming months, or if you filed an EB-2 NIW in the past, and so your priority date is now current, you would have the option to either adjust status or go through consular processing. So the benefit of adjusting status is that it permits you to stay in the United States. So even if your underlying visa status lapses, having that pending I-485 means you're allowed to stay in the United States. You can also file for work and travel authorization. And as part of your adjustment of status application, and your spouse and unmarried children under 21 are able to also file I-485 green card applications with you, and they are also allowed to apply for work and travel authorization. So for people who kind of have been living in the US, working in the US, their lives are here, their spouse and kids are here, adjustment of status is usually going to be, the best option. The downside of it, one big downside is just that once you file it, unless you're here on an H-1B or an L and meeting certain criteria, you can't freely travel internationally. So you do need to plan to file it around a time when you're okay to be in the United States for several months, even up to or even over a year, and not leave. Because if you leave, you abandon the adjustment of status. You can apply for travel authorization, and you generally will apply, when you submit your I-485, but those applications are taking several months to be approved. So definitely something to keep in mind. If there's an emergency, like let's say you file your adjustment of status, you're waiting for your travel authorization, and somebody dies, in your home country, you can apply for emergency travel authorization. Usually these will be granted, single entry 30 days, but it sometimes will allow you to kind of, make it home for these kind of important events. It's not a kind of guarantee, but, it is something to consider, when you're planning. The other option is consular processing. This is, if you're outside the United States, you don't have any status in the United States, this is going to be your only option. That means once the I-140 is approved, the approval gets sent to the National Visa Center. You will then submit a fee and some biographical information to the National Visa Center. Once they determine your case is documentarily qualified, they will send it to the consulate in your home country or where you were most recently living outside the United States. And that consulate will call you for an interview. If you're approved, you'll get an immigrant visa. You'll enter the United States and get an immigrant visa stamp, and then your green card will be mailed to you a couple months after you enter the United States. So this is really more appropriate for people who either are not in the US, don't have valid status, adjustment of status is not possible, or sometimes maybe someone's living here, but they need to travel frequently. They have many businesses abroad, they have family abroad, they cannot possibly wait for some period of time for this travel authorization. In that case, consular processing, can be a better option. I think sometimes there is some extra risk if you're living in the US on a non-immigrant visa that doesn't have dual intent. And you're, coming back and forth, you always need to be prepared. They may ask you questions at the border. That being said, if you are ultimately planning to process abroad, you'd be able to argue, I don't have intent to immigrate at this time. I'm keeping my options open, going to eventually consular process. So it is possible to go that route if you're living in the US and on a non-immigrant visa without dual intent, but just riskier. So always, good things to consider both options. So there were some updated guidelines for STEM and entrepreneurs that were also very helpful, also showing that, the government views this category as a good category for entrepreneurs and for people in STEM. The STEM specific guidelines, there's on the issue of national importance, there's a list of critical and emerging technologies. This can be really helpful to show if your endeavor, is on this list. That you have an endeavor that has national importance and substantial merit. Also, if you're a STEM advanced degree holder, this is a favored factor for the prong showing that you're well positioned to advance your proposed endeavor. It's not determinative, however, it will be viewed favorably. For entrepreneurs, they showed, they provided a list of kind of alternative evidence that can be used. I think previously, most people, when they think about the NIW, would think about scientists, people in fields where there was kind of lots of citations, lots of scholarly writings. So as this category has expanded to be more favorable for entrepreneurs, the government has provided some updated guidance about, what documentation is going to be helpful, to prove substantial merit and national importance in the entrepreneur space. So you have things like media attention for the petitioner, the business, or both, awards or grants, from government entities, letters from, actors in the industry like investors, VC funding. If you have joined an accelerator, this can be really, really helpful. If there's any evidence of kind of revenue generation, growth, job creation, a strong business plan, If you have kind of people who are in the industry saying, hey, like whatever good or product or service this company is providing, we want it. We're interested in this. This is going to help our industry. This can be really helpful. Also, to show that you're well positioned to advance the endeavor, this can be supported by proof of ownership, a critical role in a U.S. entity. Are you a founder? What is your educational background? What degrees do you have? Any particularly relevant certifications? If there are kind of letters, describing your experience from experts in the field, any evidence of investment interest, any accelerator or incubator participation, receipt of government grants, revenue growth. So you can see that the evidence that's going to be submitted as part of substantial merit and national importance often will be very similar to, the well-positioned prong. So they generally will have some overlap. So let's talk about what's actually included in the NIW submission. First is going to be proof that you meet the threshold requirements. So this is, copy of your advanced degree, certified transcripts. If you're, applying based on 5 years of progressive work experience in your bachelor's, you'll need, proof of the bachelor's, letters confirming the work experience is relevant and progressive. Or evidence you meet 3 of the 7 criteria to show exceptional ability. And as we discussed, the evidence needs to go above and beyond just meeting the regulatory language. It needs to be supported by evidence that shows that you are somebody who has expertise significantly above that ordinarily encountered in the field. So once you've met that, then you're also going to submit evidence that you qualify for the National Interest Waiver. So evidence that you have a proposed endeavor that has substantial merit and national importance. You yourself are well positioned to advance that endeavor. And on balance, it's beneficial to the U.S. to waive the requirement of the job offer and labor certification. So, this has a list of the types of evidence you can submit, news articles, academic papers, market research. You want kind of objective third-party evidence that can help speak to why your proposed endeavor has substantial merit and national importance. That critical and emerging technologies list that we just talked about, those types of things are very compelling. You also can include expert letters. So these are very helpful and necessary to demonstrate substantial merit and national importance, and also to show that the applicant is well positioned to advance the endeavor. Sometimes the letters will address both. Sometimes they may just address one. Usually they'll kind of touch on both, although they may be focused on one or the other. For example, you may have somebody, really well positioned in your industry, who hasn't worked with you a lot, but can speak to the importance of your endeavor, and then can review your resume or perhaps knows of you from, kind of your work in the field and can speak, peripherally to that. And it's very, helpful to have kind of people that know you and have worked with you so they can speak to your particular accomplishments, but also very helpful to have these outside recommenders who really only know of you through your professional accomplishments or have, viewed the endeavor and are able to provide a favorable opinion based on that. You're also going to include, the applicant's resume, degrees, any proof of professional accomplishments, things like patents, proof that you're invited to speak at conferences, any recognition in the industry, any media, any awards, any evidence of past success in the field. So, I think I touched on this before. For example, if you've built up a similar type of company and it became successful and you sold it, now you're starting a new endeavor, that type of evidence can be very helpful. Entrepreneurs can also include proof of contract, letters of intent, startup capital, business plan, all to help show the endeavor has a solid plan and is likely to succeed. So let's talk a little bit about a case study for entrepreneurs for the NIW. So in this particular case, the applicant was an entrepreneur who formed a small consulting firm to work on projects focused on improving services to U.S. veterans. I would note that this case, was initially denied, was appealed, and then ultimately approved. So shows, the type of evidence you can submit, to get a case through successfully. So for substantial merit and national importance, they had expert letters, they had media articles, they had research reports. The important part about these supporting documents is they outlined why the proposed endeavor had substantial merit and national importance. So talked about the difficulties faced by returning veterans, and the value and importance in providing services to these veterans. So, they had compelling letters from leaders in military and government, in the private sector, also from, the nonprofit sector, all kind of speaking to the importance. And then they also had media, news article and evidence. The government will often produce reports about their yearly, initiatives. Those types of things can be very helpful to show, substantial merit and national importance. And then they showed that this particular applicant was well positioned to advance the endeavor. So, these letters from government officials, business and philanthropic leaders and other experts talked about what success this person had had, how they had previously, made significant connections that had led to positive results. There was also a comprehensive business plan that kind of outlined, the activities, how they were going to happen, what the budget was, what the funding was. So it showed there was an actual legitimate plan, for how this company was going to succeed. And then also showed kind of previous success that this person had had in this area. And then on balance, as a self-employed entrepreneur, it would have been impractical for this person to obtain a labor certification, for themselves. So ultimately, they were also able to show that because of the level of experience, the level of expertise this person had, and the value of the services he was going to provide, even if other U.S. workers were qualified to perform or provide these services, the U.S. is still going to benefit from these contributions. So, this kind of, provides you kind of a roadmap to show how you can approach a national interest waiver case. There does need to be, a proposed endeavor. I think sometimes we have clients who contact us who think that kind of having an advanced degree or having a business idea is enough on its own. And as you can see here, it's really not. You do need to have, be able to show how does this proposed endeavor have substantial merit and national importance. Often just kind of saying I'm going to run a small business in the US by itself is not going to be enough. There needs to be some other, type of, hook for the business beyond that. And I think this, case study kind of breaks down, how that, how that can happen. All right, so we have reached the end of the presentation. I don't believe we've had any questions come in. So I will close here, and I hope everyone has a wonderful day. Thank you.